It's Local 6 Legal Line on this Local 6 Midday. Glad to have you along. And attorneys Mark Bryant, Austin Kennedy, these two fine-looking gentlemen to my left, attorneys from the Bryant Law Center in Paducah, answering your questions regarding criminal defense and or personal injury. And we do have something actually already on personal injury. That's what the tip was about just a moment ago. And Mark, this gentleman says, I re-injured my back in a car accident that was not my fault. Now the insurance company is asking me to get my old medical records on my back before they want to make a settlement offer. Does he have to do that?
Well, I would encourage it. I think all you're going to do is, by not doing it, it's going to slow the process down. If you've got nothing to hide and they ask you to get the medical records, I'd contact an attorney, have that attorney help you get those medical records for the past 5 years. Go through those medical records, see what is related, what is not related, what can be, what you may need to send to a third party or an independent doctor to evaluate it. To determine whether or not this car wreck may have aggravated a pre-existing condition, or whether it's a new condition, or whether it is just an old condition that really didn't do much to it. But I think it's definitely a wise decision to go ahead and get the ball rolling on that, try to get those medical records, contact an attorney to have you help that, and go from there.
I did mean to mention a moment ago that if you have a question, you're welcome to give us a call at 1-888-208-6946. And Carla would like to know something. She said, I took a settlement for my car, but now I think I have a serious neck injury. What can I do?
Well, just because you settled the car accident part does not mean you've settled the bodily injury liability part, okay? Your case is going to have multiple parts to it. You're going to have a property damage part if it was your vehicle that was damaged. You're going to have a PIP part, personal injury protection, and you're going to have a bodily injury liability part, which is against the bad driver and his or her insurance. So just because you settled the property damage part, anything you sign with that insurance company should not say that you are waiving or releasing any claims you have against their insured or that insurance company for any medical damages, wage loss, or pain and suffering that you have. So if you did sign something like that about your property damage, I would take it to a lawyer to have them look at, make sure that that's all you signed away was any claim you had for compensation for the property damage to your vehicle. And I'm sure that's the case, and then you can go forward with proving your medicals and your wage loss and your pain and suffering on your bodily injury liability claim.
Is there a statute of limitations? Typically, for example, you have a car wreck today. Is there a certain length of time that it's reasonable to say I now have body injury, such as some things show up much time later? So.
Austin, I'll let you have a criminal case if you'll let me have
sure,
a PI
go ahead,
answer.
go ahead.
Okay. Yeah, Dave, there is. There is a 2-year statute of limitations on personal injury in Kentucky. I can't speak for Illinois. I know Austin can because he has a lot of cases over in Illinois. But yeah, you got 2 years. But what you're really talking about is it's very important when you have an automobile accident to get a hold of a lawyer just as soon as you can. And the reason for that is because the insurance companies are sure working on your case in the meantime to do everything that they can to see to it that you don't get any more money than they have to give you. And so what you really need to do is pick up the phone as soon as you have a car wreck and call a lawyer. I prefer if you call down there at the Bryant Law Center, but I mean, pick up the phone and call a lawyer and talk to them about it. Make an appointment with them, because at some point in time, it is going to save you a lot of money. And lawyers that work on personal injury cases like we do, they don't charge a fee until the case is won. So you got to keep that in mind. A lot of people say, well, I just can't afford a lawyer. And on car wreck cases, they're done on a contingency fee. And if the case is lost, it doesn't cost you one dime. And if it's won, you pay it out of the proceeds. So you just got to keep that in mind.
We have a question from Cliff. I'm not sure that this relates to either topic, but currently it is a legal question, so we'll try to get it answered. Cliff's old landlords are trying to charge him for repairs to his old apartment that were already broken when he moved in. Can he take legal steps?
Well, I'd say he can. He would probably more than likely, depending on what the nature of the damages are, what the landlord's done so far, whether or not the landlord's try to bring him into court or just ask for him to make the repairs or pay for the repairs. But the first thing, again, to do would be to contact a lawyer to see if you need to go ahead and file that in small claims court or a court with higher or with more jurisdiction on the matter, or to see if there are just it's a remedies case where you need a decision from a judge to decide whether or not you are obligated to make any of those changes. If it is just a monetary change, then going the small court claim could be the way to handle it. But it's one of those where I think you need to contact a lawyer and see what your options would be.
Mark Bryant, Austin Kennedy of the Bryant Law Center have been our guest on this segment of Local 6 Legal Line.